Liability of surety. The liability of surety arises only when the principal debtor does not pay. His liability is thus secondary, so surety is treated with favor both in law and equity, and the following rules apply. The liability of the surety is coextensive with that of principal debtor unless it is otherwise provided by the contract. The surety is liable for what the principal debtor is liable. The surety must not be made liable beyond the terms of his engagement. A creditor can sue the surety without suing the principal debtor. Although liability of the surety is coextensive with that of principal debtor, he may limit his liability. In case of continuing guarantee, the liability of surety extends to all transactions contemplated until revocation of guarantee. The surety is liable for all debts payable by the principal debtor to the creditor. Accordingly, interest, damages, costs, etc., which may be recovered from the principal debtor, may also be recovered from the surety. The liability must be proved against the surety in the same way as against the principal debtor. The surety is liable to the same extent as the principal debtor. So the principal debtor and surety are jointly and severally liable. If the principal debtor is not liable on the principal debt, that is, principal debt is illegal or unenforceable, the principal debtor is discharged by creditor's breach and the surety shall also be discharged. If the principal debtor cannot be held liable due to any defect in the document executed by him, the surety also ceases to be liable on the contract. Thus, ordinarily, the liability of the surety shall be same and coextensive with that of principal debtor. Liability of surety in a void or voidable contract. The contract between the surety and the creditor is an independent contract. If the contract between principal debtor and the creditor is found to be void or voidable, the creditor can enforce the liability of the surety. Where the creditor does not sue the principal debtor within the period of limitation, the surety is not discharged. Discharge of the principal debtor by operation of law does not discharge the surety. The death of the principal debtor also does not release the surety from its obligations incurred during his lifetime. In case of minor's agreement, the surety is liable as a principal debtor.